call on my good friend, Mr. Courtney, for your line of questioning.
Thank you, Mr. Chairman. Again, as somebody who practiced law for 27 years before I came to Congress, I was actually quite sort of curious about this hearing because I actually hadn't been following this case, but seeing a unanimous decision by the Supreme Court and also a very interesting discussion of the federal Rules of Civil Procedure, Section 7, in the both the concurring opinion and the prevailing opinion. I'm really struggling, honestly. And Ms. Dudley, I've worked with the Benefits Council a number of years, have a lot of respect and admiration for the work that they do. But I honestly feel that the reaction to this decision is way over the top. And I'm not the only one. Jones Day, which is a highly respected law firm here in Washington, D.C., does a lot of defense work for companies in this type of litigation. They published an article after the court decided its case in which it said that the U.S. Supreme Court encourages Federal Rule 7A7 replies, which is a way to screen out meritless complaints before discovery. Again, I want to be really clear here because it was both the majority opinion and the concurring opinion by Alito that laid out the roadmap for defense counsel in terms of getting swiftly to a judgment on a meritless claim, and again, in accordance with the ruling that was handed down. And Mr. Rivera, I mean, I just want to make sure, I'm not reading Jones Day's analysis wrong. I mean, the fact of the matter is that, again, they gave a very clear, somewhat not used much in the past because they didn't have to use it. Okay, what the court is really saying to defense counsel is that you have to kind of hustle a little bit, in terms of the pleadings pre-discovery to get to the place where a motion for judgment can actually be heard. Mr. Rivera, maybe you can respond to that opinion of the court's decision.
Sure. I think the court, both in the unanimous decision as well as in the concurrence, offer a number of different ways. The concurrence highlights the Rule 7, as you said, to reply to an answer. But the court said there are other tools in addition to Rule 7, and that Rule 7 hasn't been commonly used doesn't mean it's not viable. To your point, hasn't needed to be used or people haven't really thought about it very much. Use it. Let's see what happens with that on both sides and see how that process plays out. But the court acknowledged you have the opportunity to have a reply, make sure there's standing question, if there's a question of the party standing to sue, there's sanctions for bad faith cases, truly frivolous cases. There are real remedies and disincentives to bring a truly frivolous case as opposed to one where people may reasonably differ. As a lawyer, you would know not every case is going to be everybody agrees, oh, this is clearly right, this is clearly wrong. There are going to be places for that kind of case management that enables frivolous suits to be.
Well, thank you for, again, just sort of reminding us that the court just didn't sort of throw the doors open to Lionel Hutz from The Simpsons to come rushing into court and try and get judgments that are undeserved. I mean, the fact of the matter is they laid out a responsible legal process for a swift judgment on meritless claims. Mr. Chairman, I would ask that, again, the Jones Day analysis of this decision, which, again, describes it as a potential boon for defense counsel in terms of getting the desired result, which we've been listening to in this hearing this morning.
Without objection.
And, again, if we override this, and again, believe me, there's a lot of Supreme Court cases I'd love for us to be holding hearings on in terms of having Congress, take action. Citizens United is obviously right there at the top of the list, which damage it's done to our elections and political process. But the fact is that we've got a case that is literally, the ink is barely dry on this decision. I mean, it was last spring that it was handed down. There clearly is disagreement, legal disagreement, about whether or not the witness's position today is that it's going to create this crisis, or whether or not it's actually going to actually help the system weed out meritless claims. And I think, again, we are rushing ahead with legislation on an issue that is far from a crisis. I yield back.